Major breaking news. We had oral argument today in the United States Court of Appeals for the 8th Circuit out of Minnesota and Missouri, addressing whether or not 18 to 20-year-olds, young adults, have a right to keep and bear arms under the Second Amendment. Specifically, this is a Second Amendment challenge to the state of Minnesota's law that says 18 to 20-year-olds may not get concealed carry permits and thus are not legally allowed to carry guns outside the home. This is a clear violation of the Second Amendment. We had a big argument in front of 3 judges today in the 8th Circuit. We're going to break it all down for you when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, major argument today. Went on for about 30 minutes. A case involving the Second Amendment Foundation and the Firearms Policy Coalition and other great groups. Bottom line is that this was a question about whether or not the state of Minnesota's law that bans 18 to 20-year-olds from being able to carry guns in public, meaning they are not allowed to get a concealed carry permit because they have to be 21 to do so. Obviously, we know the text of the Second Amendment says the right of the people, that's the key word in this case, the right of the people to keep and bear arms shall not be infringed. In the lower court, the United States District Court for the District of Minnesota, a judge, actually a left-wing judge, as a general matter, found in favor of the Second Amendment plaintiffs. Applying the Bruin case, the judge concluded that, yes, 18 to 20-year-olds are obviously part of the people, and there's no historical tradition of banning 18 to 20-year-olds from carrying guns or having guns in America, and therefore, the law of Minnesota should be struck down as unconstitutional, and it was. Then it went up to the United States Court of Appeals for the 8th Circuit. The 3-judge panel here was Judge Strauss, a future Supreme Court nominee, potentially, if a Republican is ever elected president again. So you had Judge Dave Strauss on the panel, a very serious contender. He's been on the short list for the U.S. Supreme Court before, and he will be so again. Let's see what happens there. Then we also had Judge Benton and Judge Smith. So the argument went very, very well, in my opinion, for the Second Amendment community, as well as should. I've always said that these 18 to 20-year-old gun ban cases or gun restriction cases are really very easy for us to win, and it's the kind of thing that the U.S. Supreme Court, I think, will readily rule in our favor on. And I actually think in the year of our Lord 2024, 2025, that Supreme Court term coming up, I think the Supreme Court is going to get an 18 to 20-year-old case, and I think they're going to rule in our favor that 18 to 20-year-olds are part of the people, and there's no historical tradition of preventing them from having guns, and they are full citizens in all respects, and they're allowed to have the right to keep and bear arms like everybody else who's over the age of 21. So in this argument here, it went badly for the state of Minnesota almost right from the start. Judge Benton asked, and this is kind of interesting because this is not a traditional way one might approach it, but it kind of shows and illustrates the point. Judge Benton came out and says, well, we have the 26th Amendment, counselor. The 26th Amendment says that 18 to 20-year-olds have a right to vote, that they're full citizens, and that was adopted in the 1970s. So what role, if any, does the 26th Amendment that says that 18, 19, and 20-year-olds are full-blown citizens have to, what does it speak to in terms of the Second Amendment, meaning they're protected? And Minnesota basically did not have a great argument. She said it doesn't affect the meaning of the Second Amendment, and Judge Benton literally said, that shocks me. That shocks me, which I think is a very bad sign for the state of Minnesota on the merits. So then it goes on, then the state goes on to argue, trying to explain that the people at the textual level, and remember, one of the errors or one of the attempts by Minnesota to play games here, which is what I've flagged before and I keep trying to educate the Second Amendment community on, is this. The anti-gun movement in America desperately wants to elevate every single Second Amendment controversy to the textual level of the Second Amendment fight. Why? Because at the textual level, meaning to plead in your complaint when you bring a lawsuit and on behalf of the Second Amendment, you have to plead that the right of the people to keep and bear arms at the textual level, meaning what the text means, is implicated. And the burden is arguably more on the plaintiffs in support of the Second Amendment than it is on the government. So the government, on 100%, as we've talked about before, does not want the burden to shift to the government. Because once the burden shifts to the government to come forth with a historical tradition of a particular kind of gun control law in American life, they're generally speaking toasty-mosty. They're done. Game over. They can't do it. So that's exactly what Minnesota tried to do here. The argument by the attorney from Minnesota was to try to elevate all the debate about who are the people and what are the people and what you can restrict with respect to the people to the textual level to avoid bearing the burden. And you'll see why that was so important for the state to try this and why it failed and why it's going to be devastating for the state's argument in favor of their gun control laws. So she tried to argue that restrictions in history of 18 to 20-year-olds being restricted in some way for being able to have guns cuts back on or narrows the scope of or the definition of who are the people, the right of the people to keep and bear arms. But this was immediately cut off by the judges that essentially said, wait a minute. The people appears repeatedly throughout the Constitution and repeatedly throughout the Bill of Rights, like in the Fourth Amendment and the First Amendment. So Judge Benton basically went right after the attorney and said, let me get this straight. So if we, in this case, interpreting the Second Amendment, define the people to mean 21 years of age and older, and then a 19-year-old goes out there and drives a car and is pulled over by the police, are you telling me, attorney for the state of Minnesota, that because he or she is 19 driving a car and is not part of the people, let's say, that means the Fourth Amendment that talks about the people shall be free from unreasonable searches and seizures and warrantless searches and seizures and so on like that, criminal procedural protections. The judge says, does that mean that a 19-year-old is no longer part of the people for the purposes of the Fourth Amendment, and thus the police can simply ransack and go through her car nonstop because she's no longer part of the people? So basically what the judge was getting at, and Minnesota had no good answer for this, is it seems to me that the people needs to be defined at the textual level the same, whether you're talking about the First Amendment, which refers to the people, the Second Amendment, which refers to the people, or the Fourth Amendment, which refers to the people. So textually, it must mean what the Supreme Court has repeatedly said it is, which is all members of the national political community are part of the people, which means that all Americans are part of the people for the purposes of the text of the right of the people to keep and bear arms. And that seems to be clearly where this three-judge panel was coming out. That is clearly the right answer. So the argument in favor of the Second Amendment, of course, goes like this, and it was made today by the lawyers for the Second Amendment, did a very good job. And what they essentially argued was, look, at the textual level, the people include all Americans. That includes 18 to 20-year-olds. Therefore, at the textual level, the Second Amendment plaintiffs have prevailed textually, which means that the law that restricts the gun rights of the people, in this case 18 to 20-year-olds from being able to carry guns outside the home, because it restricts the rights of the people to keep and bear arms, i.e. 18 to 20-year-olds, it means that textually it is presumed that the gun control law applicable here is unconstitutional and may not be enforced. So what happens, of course, is the burden shifts. The burden shifts. This is what the government absolutely hates. The burden shifts to the government, and now the government has an affirmative duty. Right? At this point, the Second Amendment plaintiffs can literally look out the window and sing songs and stare at the clouds. Their job is over. The job then goes to the government to come forth with a long-standing tradition of firearms regulations analogous to what we're talking about today. So the Minnesota government had to show at the relevant time periods that there's a long-standing tradition of restricting gun rights to 18 to 20-year-olds. So once the burden shifted to the state of Minnesota, which the judges basically said, now the burden's on you, Minnesota. You tell us what historical laws you have. And this is a killer point for us. The state of Minnesota basically said, we admit that at the time of the founding, 1791, when the Second Amendment was adopted, the state of Minnesota, has no statewide legislative enactments from that period that restrict the right of 18 to 20-year-olds from keeping and bearing arms. They admitted they got nothing as a matter of statute. They tried to argue there's some common law about 18 to 20-year-olds, and then the judges immediately says, okay, well, what exactly is the common law you have? Point us to it, because common law, usually speaking, means like judge-made law, and the judges pressed the attorney, and I don't think she did a great job. It's not her fault. I think she did a good job arguing as best she could, but the reality is there are no restrictions on 18 and 20-year-olds having guns at the time of the founding. So then she tried to shift the gears to the late 19th century, which again is the other ploy of the anti-gun movement. When they can't win at the 1791 period, they try to argue post-Civil War 14th Amendment, and that's what they tried to do. They said, well, in the late 19th century, there were some restrictions, arguably, on 18 to 20-year-olds being able to get guns, but that sort of blew up in Minnesota's face when they argued that, because Judge Benton, for example, came out and says, wait a minute, in the late 19th century, the kind of laws you're pointing to, there was a distinction in some states in the late 19th century, which is not the relevant time period, because 1791 is the time period. I mean, why would you interpret the Second Amendment as meaning anything other than what it meant when it was adopted in 1791? But set that issue aside. But even when you go to the 19th century, the Judge Benton, I think it was pointing out that there were distinctions between women technically became adults in certain states at 18, but in those same states, men became adults at 21. So immediately the judges are saying, are you saying, Minnesota, is this your argument that because you want us to look at the late 19th century, and because women were adults at 18 and men in some states were adults at 21, are you saying that 18-year-old women have the right to keep and bear arms, but not men? And it's pretty clear the judges were not interested in adopting such a view. They were clearly basically articulating kind of, well, that obviously can't be the rule. That makes no sense. So that really was devastating kind of an observation by the court. But then let's carry on. Some of the other powerful arguments that I think will prevail, and by the way, I think we are going to win this case. I think they are going to rule that the Second Amendment protects the right of the people to keep and bear arms, and that does include 18 to 20-year-olds. We're going to talk briefly about a technical procedural argument called mootness, which I think at the end of the day is not going to be a problem either, but we will talk about that in 1 minute. So now, again, textually, it's pretty clear that this court agrees that the Second Amendment people is going to be defined the same way the Supreme Court has defined it. We've talked about this before. It consists of all Americans, and therefore I think textually we are going to win this case called Worth versus Jacobson. So now the burden has shifted to the government, and the question is, what historical analogs have they been able to come up with? So again, there was a series of analog discussions of the founding era, and it was pretty clear there was no founding era history that was favorable to Minnesota. In fact, it went just the reverse, because one of the things we've talked about repeatedly here is the Militia Act of 1792. Again, just think about this for 1 second. The Second Amendment is adopted in 1791, along with the rest of the Bill of Rights. In 1792, like a year later, guess what? The Militia Act of 1792 is adopted, and the Militia Act of 1792 is a federal law that applies to all the states. It's a national law. And what did they define as who constituted the federal militia that had to bring their own firearms with them to militia musters? And the answer is, it was all able-bodied, white, 18 to 45-year-old men. And we know from Heller, for example, that the militia is a subset of the people, right? You have the people, they have the right to keep and bear arms, and then the militia is a subset of what? Of the people. So if the subset, i.e. 18 to 45-year-olds at the time of the founding under the Militia Act of 1792, had an obligation to bring their own private firearms with them to militia musters, it pretty much establishes that a minimum 18 to 20-year-olds are part of the people. But then let's go on. There was a discussion to say, well, but that was for the militia purposes. Yes, but here's the key. The guns that they brought to militia musters were their own guns. And here's what I think was the killer point in favor of the Second Amendment during this argument. There was then a colloquy going back and forth about, okay, so the 18 to 20-year-olds had a duty to get their own private guns, whether they got them for, they bought them themselves, or they bought a gun, or their parents got them a gun as a gift. It doesn't matter. The point is that these 18 to 20-year-olds had to bring their own privately owned firearms, their own privately owned ammunition, their own privately owned cartridges, their own privately owned pouches, and so on, and black powder within the militia musters. So the question then became, and this is the killer point, is this. When those 18 to 20-year-olds were not yet in the militia muster, what were they allowed to do with their own privately owned guns and ammo and black powder and so on? When they had the guns, which they needed to possess for militia musters, but they weren't actually at the militia muster. Meaning the rest of their lives, when they had the guns for the militia, but they weren't not at the militia. Obviously, at that point, the question became to the state of Minnesota, during that time period when they had the guns at home in their private lives, were there any restrictions on their ability, 18 to 20-year-olds' ability at the time of the founding, to use those guns for any and all lawful purposes, including but not limited to carrying them, hunting, shooting, target practice, whatever? And the answer is, No, there were no restrictions. So it's pretty clear that we should win on the Second Amendment grounds. This should be a slam dunk. And I've always said that 18 and 20-year-olds, I always think is a very easy case for us. And if and when it gets to the Supreme Court, and I think it will be there next term, I think we will win this case big time at the Supreme Court. I don't think it will be a problem at the end of the day. Now, with all that said, there was one argument that you could argue makes you concerned. There was a procedural argument. On the merits, we're not going to have a problem. But there's a technical procedural argument called mootness that Minnesota is really trying to push. And what Minnesota was arguing was this. Look, at the time this lawsuit was filed many years ago, there were 18 to 20-year-old plaintiffs. But those 18 to 20-year-old plaintiffs, apparently, as I could glean from the argument, the original 18 to 20-year-old plaintiffs are now today over the age, they're 21 years of age or older, which means that the plaintiffs themselves, are able to carry guns, which means that the case is now moot because, as you know, being the smartest person in the room, under the Article 3 of the U.S. Constitution, the federal courts are only legally allowed to hear cases and controversies. And because Minnesota argued that the 18 and 20-year-olds that brought this lawsuit are no longer part of the lawsuit because they're no longer part of the lawsuit because they're 21 years of age, they can carry, their claims against Minnesota are now moot because they can carry. There's no more controversy. They can now carry guns for the rest of their lives and get a permit, whatever. So there was a debate here, or discussion here, about whether or not the organizations had properly added new plaintiffs that were now today between the ages of 18 to 20 years of age. So therefore, the case was not moot. And there was some back and forth about this. And I don't think I'm particularly concerned about the mootness argument for a variety of reasons. One of which, this is a facial challenge to the statute, which means, well, I mean, as long as you have someone arguably with standing. The question is, facially, does this law apply to all Minnesotans that are between the ages of 18 and 20? So I think the fact this is a facial case is very helpful. The second is they asked Minnesota, what kind of discovery would you want in the trial court of the plaintiffs? And I don't think they had a very good argument as to why they needed any discovery at all. There's precedent of swapping out plaintiffs. And last but not least, is more of a common sense point, there is an exception to the mootness doctrine called futility. And the way that works is to think about it in the context of, like, if you're pro-abortion suing over an abortion restriction, well, obviously we know that every 9 months, a pregnant woman's case would become moot, right? So does that mean that the plaintiffs that are suing to challenge on constitutional grounds abortion restrictions, does that mean that literally every 9 months, a plaintiff in the abortion context would have to replace the female plaintiff with another pregnant woman and go on and go on and go on? Because again, every 9 months the case would become moot. And we know from this channel that it takes many years in many instances for a case to go womb to tomb. And as a consequence, you're always going to moot out like an abortion case. And when you're dealing with 18 to 20-year-old cases like this, again, you're always going to moot out because the case is going to go on for usually a number of years. So 18 to 20-year-olds will time out because they're going to turn 21 and those restrictions won't apply to them anymore. And that will make the case moot. But I don't think at the end of the day, this 3-judge panel is going to go down that path. They asked a series of questions probably because they want to write about it in their opinion, but I don't think that procedural problem is going to ultimately pose an issue. Okay, to sum up, in this case of Worth versus Jacobson before the U.S. Court of Appeals for the 8th Circuit out there in Minnesota, Missouri, and so on, I think we're going to win this case on the merits. They're going to conclude that 18 to 20-year-olds are part of the people, and there's no historical tradition of restricting their gun rights. I think it will then be supplemented with the fact that under the 26th Amendment, 18 to 20-year-olds are full-blown adults now. So even if you could argue that at the time of the founding they were not adults, the fact is they're now adults today. And I think one of the other things to keep in mind is, if you think about it, now, since 18-year-olds are full-blown adults, it would be simply wrong to say you're a full-blown adult in all respect, Mr. 18-year-old or Miss 18-year-old. But the one thing we're not going to let you do when you move out and get your apartment or your first job or buy your first car and go out into the world, the one thing we're not going to give you the right to do is to defend yourself under the Second Amendment. We're not going to let you protect your life, even though we expect you to pay for yourselves, you to pay for your health insurance, you to pay for your college, you to live a life, you not to be a dependent, and so on and so on. So we give these people, all the rights and privileges of being a citizen once they turn 18, but then deprive them the ability to protect their lives and the lives of their families because they could go get married and have kids, that seems incongruous, and I don't think that's going to fly with this three-judge panel of Judge Benton, Judge Smith, and Judge Strauss. I think it will be at least 2-1, maybe 3-0 in our favor, but only time will tell. I suspect we'll see a decision probably in the next 4 to 5 months. All right, there you have it, folks. Hope you learned something here today at the Four Boxes Diner. Make sure you subscribe at Four Boxes Diner on X, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.